Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments that have taken place in the last few weeks in the realm of international taxation. For this, we have selected three important cases. The first one discusses the taxability of income from installation activities performed by foreign entity in India. The second one discusses the treatment of compensation on termination of non-exclusive license agreement in the hands of a foreign company. And the third one discusses the characterization of grouting activity performed in Indian territory as existence of permanent establishment. Our first case revolves around taxability with regard to installation activities performed by non-resident entity through its liaison office in India.
Let's understand what exactly happened in this case. The SSE in the present case is into the business of designing and supplying hardware and software product for setting up GSM cellular radio telephone system. The dispute arose when the software supplied by the SSE to the telecom operators was held to be attributable to its PE in the form of Nokia India, and hence income from such supply was brought to tax under the head of royalty. Not satisfied, the SSE approached the appellate authority, who also upheld the assessment order to the extent that SSE had carried its business in India through its liaison office on regular basis. Thereby, proving its business connection in India, the appellate authority also upheld the finding of AO that consideration which had been received by the SSE for the license of software in India was clearly liable to be taxed as royalty.
Now let's see what the tribunal finally decided. The technical expatriates placed in India for assisting with performance of installation activities and not to carry out any business relating to manufacture or sale of network equipments cannot be reckoned as fixed place PE. Income earned by non-resident entity from offshore supply of equipment to Indian customers cannot be brought to tax in India in the absence of its business connection in India for the purpose of such equipment sale. When there is no income whatsoever from the installation activities which has been earned by the non-resident entity in India, which can be attributed directly or indirectly, there is no liability to tax in the hands of such entity. Services of telephone, fax or car facility provided by the Indian liaison office to the employees of its parent overseas entity visiting India cannot be termed as fixed place PE. Moving on to our second case, the tribunal was approached to decide as to whether the compensation received by a non-resident entity upon termination of non-exclusive license agreement is to be taxed as royalty or income from other sources.
Let's understand what exactly happened in this case. The SSE in the present case operates global card payment network. In the relevant year, the SSE entered into a network participation agreement with Citibank. In pursuance of the same, the Citibank was granted non-exclusive right for using the know-how and technical process, and in turn the SSE received participation fee. Such income was duly offered by the SSE as royalty as per the treaty provisions. The dispute arose when the Citibank terminated the network agreement and paid a compensation of USD 10 lakhs to the SSE. Though the SSE accepted that such compensation was in nature of the revenue receipts, however, claimed that it could be taxed in the USA only as it had no PE in India. The department, however, refused to accept such contention of the SSE and brought the compensation to tax as royalty on the premise that it flows from the original agreement.
Now let's see what the tribunal finally decided. When pursuant to the termination agreement, the non-resident entity had not provided any technical know-how as provided in the original agreement, then compensation received by it pursuant to such termination cannot be attributed for the use of the know-how. Such compensation receipt is only a business receipt falling under the head profits and gains of business in the hands of the non-resident entity and hence is not taxable in India. Now let's move to our last case, where grouting activities performed by foreign company in Indian territory were to be construed as fixed place PE.
Let's see what exactly happened in this case. The SSE company, a tax resident of UAE, is engaged in the business of undertaking grouting work for companies in the oil and gas industry. While scrutinizing the returns of the SSE, the AO, however, noticed that no income from this contract had been offered to tax in India, on the ground of absence of PE in India. He therefore treated the income from grouting to be taxable services arising out of fixed place PE under Article 5(1) of the India UAE DTAA and the income from offshore supplies as a business profit attributable to such PE.
Now let's see what the tribunal finally decided. Activities involving laying of pipelines and excavating and dredging cannot be held as construction under Article 5(2)(h) of the Indo-UAE DTAA. In order to bring any other establishment which is not specifically mentioned in Article 5(2) of the Indo-UAE DTAA, there must be existence of a fixed place of business, and through that place of business of an enterprise is wholly or partly carried out. The UAE resident entity, having fair amount of permanence through its personnel and equipments within the territorial limits of India to perform its business activity of grouting, falls within Article 5 Clause 1 of the Indo-UAE DTAA. With this, we wrap up this episode of Legal Wrangle. Please feel free to share your views with us at editor@tiol.in. Thank you for watching. Goodbye.